Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Long time no see, everybody. Thanks to the 36 people who made it over here. Please hit that like and subscribe button if you haven't. I would greatly appreciate it. This case is going to be this case, unlike the Hales case that has captured the YouTube's attention. This case has captured the world's attention for a multitude of reasons, both positive and negative. We saw the best and worst of society when Charlie Kirk was shot. You saw the best of people coming together, having prayer vigils, whether people believe in God or not, respecting people's rights to believe what they want to believe. And then you had the worst of society who got on social media, clapped, congratulated, sang songs celebrating another human's death. And whatever you think of Charlie, whatever you think of anything, celebrating someone else's demise or death, I have words for those people that would get me yeeted off YouTube so fast. There's a special place in hell for people who celebrate other people's deaths. With that being said, courtesy of Andrea Burkhart's Substack and her excellent work and assistance in paying for all these documents, we have access to all the documents in the Charlie Kirk case. The defense has been trying their damnedest to get the media kicked out. Yesterday, we had gone over last Friday's live hearing, and because so many things in this case are being kept behind closed doors and having closed hearings, they close it, they open it up, they close it, they take recesses. We've decided that we will no longer be covering those hearings live. We will be doing a replay crew sometime a few days later, so we can skip through the BS and everything that we did. There has been motions to disqualify the prosecutor's office because one of the a prosecutor who is a supervisor in the prosecutor's office in Utah County, his daughter was there, and they have been trying to get the whole entire prosecutor's office disqualified because of that. It's been a whole thing. It's been a whole thing. So we are going to get into 3 motions that were filed last week. We are going to get into a motion to classify, the motion to exclude still photographers and TV cameras and microphones from the courtroom as private. and on for Looker, thanks for becoming a new YouTube member. I appreciate it. Oh, housekeeping with the members. I do have a community post up that was put up at the beginning of the month talking about every case we're talking about. You guys can put your comments, put what you think of the cases, where you think the cases are going to go, and then next Saturday, the 31st, we will be doing a members only live stream kind of discussing the cases, your comments on the cases, and whether those comments aged like a fine wine or they aged like milk. Only thing about that community post, there are rules. No attacking people's personality. You attack the facts. You attack people's actions, not people. No name calling. I will be deleting comments that are name calling because as much as I don't like people, we have to live by a certain standard and treat people like you want to be treated. So there's that. With that being said, treating people like you want to be treated, what I forgot to mention, and I said I was going to mention on the other stream, was this. I posted a short about a GoFundMe. I usually don't share GoFundMe links at all. However, if you were thinking about super chatting me or doing a PayPal or whatever, a Ko-fi tip, anything like that, this week or next week, please don't. I would rather have you donate your funds to this. This was set up by Captain Kern. Captain Kern is also a good friend of this channel. Captain Kern is a good friend of mine. Back last January of 2025, he was on this channel. We did a few streams together where we went through all the documents in his daughter's tragic unaliving case. TLDR, his daughter was unalived by her spouse or her significant other at the time in a domestic violence situation. And we went through all the legal documents to figure out what went right and what didn't go right with the trial. However, he has set up this because his daughter Tessa's best friend, so she has escaped a long-term abusive relationship of her own. Now she is currently, her and her 2 small children are currently living in a shelter. They left with the clothes on their back. They did not take anything. They have no personal effects. They have nothing. So this is the GoFundMe link, and I have, I'm not trying to out anybody, but like, I led by example here. Like I donated, so I'm not just trying to tell people to donate and not do anything myself. However, we take domestic violence and domestic violence issues very seriously. And this woman and her children have the opportunity to start a new life in a situation that is not abusive. I'm trying to use words that YouTube is going to like, but at the same time, like, you just got to call a spade a spade. I did share a short on this because I talked about it in yesterday's stream. However, I will post the link for it. If you guys want to, donate, that would be great. If you don't, I understand been so many GoFundMe's lately that, you kind of get a little GoFundMe, you know, you get a little, mm, you know. However, this is one that is personal to me because I read all the legal documents behind what had happened to Captain Kern's daughter, and anybody who has the chance to get away from that situation, I will be more than happy and excited to support. So, you know, so it is there. I posted it on my YouTube as well, and I will be making a community post about it. But that was started by friend of the channel, Captain Kern. Captain Kern and I we talk offline and off YouTube as well. Uh, so it's somebody I trust. I don't share GoFundMe's very lightly. However, this one was when I saw it, it just touched me. So, yeah. So we shall see how it goes, but to the best of luck for her. So, all right, getting into these documents, we are going to start with news media. This was filed on the 15th, the day before the hearing. News media's memorandum and opposing motion to classify defendant's motion filed January 9th. Fucking weird. Yes, Captain Kern's a very special human being. He's been through a lot. I don't know. I felt so privileged that he shared that experience with me and let me share his story. That I just, oh yes. Yes. Anyway, trying to get back on track here, but I forgot to share that. I wanted to share that in the stream that had almost 300 people watching, and I forgot, like a dumbass. The Desert News digital media doing business is KSL TV, whatever. Utah Headliners, chapter of Society of Professional Journalists, the Salt Lake Tribune, all these people, all collectively the news media, hereby have opposed defendant's motion to classify defendant's motion filed January 9th, because this court granted the motion without affording the news media the right to oppose it and be heard. The news media further requests that the court vacate its order on the motion to classify entered January 12th. Nothing happened to him. His daughter's best friend recently got out of a not so great relationship and is staying in a shelter and has nothing but the clothes on her back and 2 children to take care of. Currently has next to nothing as far as possessions, so he set up a GoFundMe for her. He calls her his bonus daughter. Her youngest child, her daughter, was named after Captain Kern's daughter. That is how close they are. So it's a personal situation. The defendant filed his motion on Friday, January 9th. The motion itself provides almost no explanation for why the presumptively public filing should be classified as non-public, nor does it, or the order granting it, engage in any of the substantive analysis required by the Rule 4-202-046. That alone renders the order improper. See also Supernova Media v. Pia Anderson case law. Because of the public's interest in open court records, a court must make the findings required by the rule, even when all parties stipulate to sealing. The failure of a district court to make necessary findings in an abuse of discretion unless the facts on the record are clear, uncontroverted, and capable of supporting only a finding in favor of the judgment. You got to do what you got to do to get by. There was someone on this channel in the last stream that what used to be blocked on the channel for making a comment about my daughter. They were unblocked because, you know, I don't hold grudges because it takes too much time. But yes, Malin, I did, with the permission and the assistance of Captain Kern, back in January of 2025, did 3 streams called A Father's Love, part 1, 2, and 3. If you want to know the story and you want to see the documents involved, that is the place to go. Moreover, this court entered its order granting the motion the following Monday, January 12th, without affording the news media the opportunity to oppose the motion or be heard. On its standing order for that rule, notice of motions for classification entered December 9th, 2025. December 29th, 2025. This court stated the news media would have 7 days to oppose closure request after receiving notice. Because that did not happen here, this court's order should also be vacated on that ground. You know what? Sometimes, like, I am all for unblocking people after a certain time because of certain things. However, I am not sure if I was in his situation and somebody made comments about that particular incident, I would ever unblock them. They'd be lucky that I didn't know where they lived. Like, I have a hard enough time when people talk about my daughter anyway. I can't even imagine what my brain would do if someone talked about that in an inappropriate way. So, yeah. Ugh. On the substantive level, the news media understands that the basis for defendant's closure request is that the motion at issue concerns evidence defendant plans to argue would be inadmissible at trial. I have thoughts on this. As many trials as we've watched on this channel, no other defendant, no matter the public nature of the trial or the public's interest in the case, has ever been afforded the amount of bullshit and the amount of, like, yesterday I basically said, I made a comment when Tyler Robinson's lawyer was speaking that I'm sorry that Father Time here was born before courts or before cameras were invented. But cameras will be in the court, like, are in courtrooms, and they are on the defendant. They act like Tyler Robinson is the first defendant ever in the history of the United States to ever have a camera in his courtroom. OJ, do we need to go back that far? OJ Simpson, cameras in courtroom. Sarah Boone, Joseph Furlano, the guy who killed his wife in New Hampshire, on the anniversary trip. Van life. Angel, it's Grandpa? Yeah. Grandpa's here? Yeah. Is Grandpa back? Do we need to unlock the door? Yeah. Okay. So I'm going to oh, you want that? Yeah. Okay. So it's I don't blame him. I don't blame him. Yep. Debbie, the little is pointing at your avatar, and is that cool? Yeah. You want me to bring it back up? There you go. I know. please don't push on the monitor. But yes, there's her picture. Angel bug. It's right here too. Look, it's right there. Oh. It is just a thing that they want their I see. Welcome to commentary with little squidlet. If I remember, I was in like either 3rd or 4th grade during OJ. We did mock trials on the bus, and in like 3rd or 4th grade. I don't know why, but we did. But it captivated a nation. But his attorneys are acting like they are the only people to ever be on camera. Oh. Okay, hold on, baby. There you go. There's not much on there. It's just it's annoying, and I want to make I kept yelling at the screen yesterday, almost to the point where I had to mute myself, and it was like, oh my god, people, you act like you're only like it, I don't know. That one was before my time. You're beautiful. You're gorgeous. You want to call Grandpa's busy right now, baby. That's what I'm here for. Well, thanks, Kirby. Good to know you're not here for me. I do miss the stop pushing on it, please. I do miss the other like 200 people that were here like an hour ago, but you know. Come here. Yes, I agree with this. Everyone needs a Debbie Webb in their corner. And Debbie, if you ever need anything, we are here for you too. It's okay. It's okay. It's okay. It's okay. It's okay. Hey, Taz. Speaking of someone who is good to have in your corner. She's right here. She refuses to move, but hey, stop. Stop. She's trying to hit my stream deck. So Papa Squid is used to the cold. Yeah, you know. You were expecting 12 plus inches Sunday. Where are you at? Because I am from Wisconsin, but I don't live there. Thank goodness. Like, hey, shh. Here, you want this? Here, there you go. You're welcome. Okay. Hold on, beautiful. Mwah, I love you too. There you go. Thank you. You're welcome. Bye. I love her. Can somebody, aka Jeffrey, can you keep an eye out on my my YouTube feed and my channel and see if there's a short that's going to be uploaded shortly, because she has my phone. All right, getting back to this. On a substantive level, the news media understands the basis for the defendant's closure request is that the motion it issues concerned evidence defendant plans to argue would be inadmissible at trial. Apparently on the assumption that pretrial suppression of hearings and the motions relating to them are necessarily non-public. The law is the opposite. Exactly. And because the defendant has indicated he intends to keep making this argument for future exclusion and suppression motions, the news media submits this opposition to correct that misimpression. In its seminal decision in Richmond Newspapers v. Virginia, 1980, the U.S. Supreme Court recognized a First Amendment right of access that is inherent in the very nature of the criminal trial under our system of justice. Subsequent decisions following this recognition of the structural right have left no doubt that the public's First Amendment right of access applies with full force to suppression hearings and related court records. Yeah, the defense, and I can't put it any other way, the defense is arguing, and they keep arguing that having cameras in the courtroom is unfair to their client. He acts like he's the only fucking person who's ever had cameras in a courtroom. Controversial. Ahmaud Arbery, cameras in courtroom. Kyle Rittenhouse, cameras in courtroom. Where I wish there was cameras in the courtroom right now is a case out of Milwaukee that I'm sort of keeping an eye on. A guy is on trial right now for being a security guard at a convenience store and unaliving someone who came into the convenience store and stole a box of Little Debbie snacks. In 2023, kicker is he got out of prison in May of 2023 after serving time for first-degree reckless homicide. After unaliving someone with a pew-pew in the back of the head. He shot someone in the back of the head for stealing Little Debbie snacks. Make that one make sense? Yeah. So I wish there was cameras in the courtroom for that. That trial started the 20th. I will be keeping an eye on it and giving you updates. That'll probably be in our legally fuck around and find out Friday, tomorrow. Because it's an interesting case if you read the background on the defendant. So, you fell again? Oh. And y'all, I don't want to like self-promote, but I don't want to self-promote, but I do have another channel that has to do with that, and we have 3 videos of a 5-part series on fall prevention. I hate seeing people fall. Chandler v. Florida, 1981, Supreme Court ruled states could allow cameras, opening the door for more state-level adoption. And then you get places like Indiana, where that judge in the Delphi case was one of the judges that pushed for cameras in a courtroom, but did not allow cameras in her courtroom in the Delphi case. Make that shit make sense. People versus DeBeer. A court may not close a suppression hearing on a possibility that there might be tainted non-public evidence that might impair the selection of an impartial jury, which could very likely be said of every suppression hearing in every highly publicized case. U.S. v. Credin, vacating an order to closing suppression hearings in the prosecution of 4 abscam defendants. U.S. v. Brooklier, noting increasing importance of pretrial procedures in the modern era, and rejecting effort to close suppression hearing to determine admissibility of evidence based on allegedly misconduct by FBI agents. Miami Herald v. Lewis. The trial court should begin its consideration with the assumption that pretrial hearings to be conducted in open court unless those seeking closure carry the burden to demonstrate a strict and inescapable necessity for closure. Ex parte Hearst Argyle Television, reversing a trial court order closing a pretrial suppression hearing in a capital murder case because closure would not prevent additional publicity and did not satisfy the constitutional test. So much case law. I love when documents are loaded with case law because it's like, here's my opinion, here's what I think you should do, and this is the case law that backs up my opinion. I just don't like when people just go, here's my opinion and you should believe me. It's like, no, show us the receipts. And in a legal document, it's my opinion that case law and precedent is your receipts. And I love case law after case law after case law. It's like, thank you. Because if you provide one case, we've seen in Jeremy Hale's case where things can be taken out of context, and case law can be cited incorrectly. However, when you keep what they have 5, 6, 7 here, when you have this much case law, it's virtually impossible to take all 5, 6, however many they have out of context to all say the same thing. It's, hey, Calvin. 2 broken ribs. Hey, Taz, DM me. I have questions for you, and I also have things that could help. I know I haven't worked in the hospital in 5 years, but I was on the rib fracture committee in the hospital. And there's been a couple other people who I hopefully have helped with rib fractures. Some of them may or may not be watching right now. Just a thought. I'm gonna do a deep dive on cameras in courtrooms tonight. If I find anything out, I will put it in Discord. You are awesome. You are awesome. And I don't have access to like Westlaw or anything, which would be really easy to input these cases, but it's one of those things of like I'm not a lawyer, so you know. People versus Legrone. Reversing a trial court order denying public access to hearing on motions in limine. This application of the right of access to suppression hearings derives directly from the rationale of Richmond newspapers. Every single motion to exclude evidence involves or discusses evidence that may not be introduced at trial. If the fact were alone enough to warrant a closure, there would be no meaningful right of access to such hearings. The law in this area, however, is exactly the opposite. You're gonna call Daddy?
Yeah.
Okay. I think he's on his way home. He's on his way home, so he won't answer. He won't answer. But you can try. In its unanimous opinion in Waller v. Georgia, the U.S. Supreme Court. He's busy too. Everybody is busy. It's okay.
Sorry.
It's okay. You want to sit on mommy's lap?
Yes.
Okay.
No.
Okay, bye. You want to sit on mommy's lap? Yes. And then she bolts the other direction. The U.S. Supreme Court explained why, as several of the individual opinions in Gannett recognize, the suppression hearings are often as important as the trial itself. They are. And I think hearings are actually more important than the trial, because you get to see what goes on behind the scenes before the jury gets in the room, before the jury even gets chosen. And you get to see why things take 1.5 to 2 years to get to trial. Shush. I timed out and deleted the comment of Jeffrey yesterday for this. In Gannett, as in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty pursuant to a plea bargain. The need for an open proceeding may be particularly strong with respect to suppression hearings. And I just have this weird, and I could be 100% off base, but for some reason, the look of Tyler Robinson, the way his attorneys are arguing things, the fact that this is a life or death case. No, I timed you out for 10 seconds. You just didn't know. This reminds me of a little bit of the Koberger case. In the sense of it's a life or death, they keep pleading his innocence, that he didn't do this, not guilty, all of that. Tried to drag out a bunch of things in pretrial motions, but then at the 11th hour pled guilty with the deal of taking the death penalty off the table. I just see this for some reason, and I could be 100% wrong. Like, I'm not a lawyer. I just go based on behaviors and what I see and similarities. And for some reason, I can see all of chat singing. Okay. I have to get the front door. my dad is back and I have the door locked. So I will be right back. All right. Thank you. Papa Squid is back in the house. I just locked my door and he doesn't have keys. And good night, Malin. If you're leaving, there's a lot of fire trucks on my street. So thank you for today. Take care. Have a good night. And yes, please, everyone, hit the like button. It is free. Share this out. I know that Andrea Burkhardt is doing amazing work in this, but this is just my from a prospective juror's perspective. I know I'm not a lawyer, but I am a prospective juror in any number of these cases all over the country. And it's just interesting to see how different lawyers and different courts operate all over the country. Because we are in the same country, but things are different. Rules are different. Laws are different. Mommy mode, I didn't forget the song. No, it was answer the door mode because it's locked. No, we actually have the baby preventative doors, the child-proof door opener things. I just locked the door because I don't want to have to use my Second Amendment right to protect my family if I don't have to, and if a simple door lock will keep someone out of my house to the point where I don't have to call 811, I will do it. But my dad doesn't have keys to my house, so it's yeah, I don't want to have to use a wireless hole puncher to defend my family, even though it stays. Oh, Timothy, we got a Mosin Nagant. This stays in one spot, and the other part stays locked right there, and we're ready to go. But just because I will play the F around and find out game does not mean I want to. Backhoes are expensive. Speaking of backhoes, when we're done with this document, we have story time with Squid. All right. Another CDN's living on our land, news gatherings, and the law. A decision that evidence is admissible will often be followed by guilty pleas. A decision that evidence is constitutionally inadmissible often precludes further prosecution. State v. Greco, public access may be even more important in pretrial evidentiary hearings than at a trial, since pretrial hearings are often crucial stages of trials. Yes. These same interests in access were echoed by the Second Circuit in the Herald Tribune Company, 1984. It makes little sense to recognize a right of public access to criminal courts and then limit that right to the trial phase of a criminal proceeding, something that occurs in only a small fraction of criminal cases. Yeah, only a small number of cases actually make it to trial. There has been a number of cases. I have not streamed a trial since Lake and Riley. And the reason that I have not done that is because all of the cases that I have done, it's either Lake and Riley or Colin Griffith is the last one I did. With that being said, I have followed 3 or 4 different cases that all took plea deals. Christopher Schultz took a plea deal and then self-deleted. The the case out of Utah where a transgender woman unalived her parents, took a plea deal. Like Derek Rosa, we have to get into the plea hearing, but Derek Rosa out of Florida, where he is accused of unaliving his mother, took a plea deal. Not everything goes to trial. In fact, very few cases actually go all the way to trial. So limiting the public access and the cameras to just trials is like what, maybe 10%? It doesn't make any sense. There's a significant public benefit gained from public observation of a criminal proceeding, including pretrial suppression hearings, that may have a decisive effect on the outcome of prosecution. Yes, education is a huge thing. It's why I have a channel. It's because the more people that talk about how our criminal justice system works, maybe people will frickin' stay out of it. Just a thought. Also, in the Hales case, for example, you know how many people that we've talked about and we've discussed have no idea how the how the justice system actually works, and they want the judge to do this and the judge to do that. That's not the judge's job, and it's not the judge's role. It's actually unethical for the judge to do certain things that people want the judge in that case, in those federal cases, to do. So, looking at documents, pretrial motions, pretrial hearings, it's not only good to keep our judges and our prosecutors accountable, because if they're behind closed doors, they can do shit. Transparency is good for accountability, because if people know that they have to be transparent with their actions, they're less likely to be full of shit. In my opinion, this is just my personal opinion. But if you know that your ass is going to be on camera or someone's going to read your pleading, it's a lot less. I have to go close the door. My dad is. You think I'm loud? My dad is louder. Thanks, guys. He's on the phone with his builder, and I'm like, I can hear every word he's saying, and I can't concentrate. You think I'm loud? I can hear my dad like he's standing right in front of me. As the news media have already briefed at length, the constitutional standard for closure is extremely rigorous by design. It cannot be overcome with speculative assertions and general arguments that some piece of evidence might be excluded at trial. Tyler Robinson's attorneys act like he is the only person who's ever been on camera in a courtroom in the entire history of the United States. You heard nothing, but I heard everything, and I have a attention span problem of my own. Hard enough keeping myself on track sometimes, let alone when I can hear other, you know. Just got a weather warning. They're talking about extreme cold till 11 a.m. Saturday, wind chills to -30. If you have to be outside, make sure to cover all exposed skin. What state are you in? Because yeah, they even closed the schools on Friday, apparently, in some places in Wisconsin because of the wind chill. So the public's right of access is not limited to the trial. It extends to all phases of the proceedings, including motions to exclude evidence. Because it appears that defendant's basis for requesting closure here rests only on the erroneous assumption that the public has no such right, his motion should be denied. Ados, attention deficit. Oh, shiny. Yes, I do love shiny things. Speaking of shiny things, I still have not found my ring. Michigan. Then I'm from the other side of the pond, the mini pond. So this is as attorneys for the news media. All right, and this was filed. And I appreciate that these motions are all like 5 pages. These motions are not like 20 or 30 pages. I can appreciate that. But once again, thank you to Andrea Burkhart and A Burkhart Law. If you do not subscribe to her, you really should. Her channel is awesome. Self promotion. I prefer that you watch these hearings and trials and stuff with me, but she's awesome and I like her a lot. So this one is the motion to classify and exclude still photographers, TV cameras, and microphones from the courtroom as private. This was filed on the 16th. Defendant Tyler James Robinson, by and through undersigned counsel, moves this court pursuant to Utah Rule of Judicial Admin to classify defendant motion to exclude all still photographers and exhibits as private. The primary basis for this request is that the motion compiles a substantial number of electronic media references and that evidence violations of Utah state law, the violations of this court's decorum orders, and overall threaten Mr. Robinson's constitutional rights to due process. I am all here for defendants' rights. And even though I don't like a defendant, even though I think someone is guilty AF, I am all for maintaining defendants' rights and due process, because if it's this person tomorrow, this defendant today, whatever, this defendant today, so-and-so, we don't, Tyler Robinson today, it's you tomorrow or me tomorrow. Because when the state takes away a right, they really don't like to give it back. Just a thought, Yeah, as compared to a due 60-page repetitive motion or of irrelevant information, or a ellipse 38-page trauma dump of I hate everybody and everybody hates me motion. Although entertaining, it makes you lose brain cells. Mr. Robinson's constitutional rights to due process, a fair and impartial jury, to counsel, to be free from unreasonable searches and seizures. Okay, I am not a lawyer, so definitely not a constitutional lawyer. But this would be a good question for Rackets, because he knows the Constitution, because he, all of that. Free from unreasonable search and seizures in the 6th Amendment. Is having cameras in the courtroom and making your motions public, and having your motions be public because they are public information. How is that have anything to do with unreasonable search and seizures? I mean, he mentions the 6th Amendment, and it's like unreasonable search and seizures and free from cruel and unusual punishment. How is having your public information out there? How is I'm confused, and like this is where like sometimes lawyers just piss me off, because I'm like, and Taz, thanks for the 2 Squid Pro Quo memberships. Hung Hero's got some personal things going on right now. Pray for him and his family. He needs all the prayers he can get right now. So he's got some personal stuff, so he might be in and out. He'll be here when he can be here. 3D world is just taking over. I just think this is just me putting free from unreasonable search and seizures and cruel and unusual punishment in a motion, why a motion should be sealed, because you don't want public information to be public information. The mental freaking gymnastics. Like the mental gymnastics just make me fucking laugh. Yeah, they're worried about lip readers telling what he's talking about with his lawyers. Like, you saw Amber Heard. Amber Heard, when she talked to her lawyers, went like this. How freaking hard is that? Like, am I wrong? We even saw Amber Heard and Johnny Depp go like this, take a piece of paper and do this when they were talking to their lawyers because they knew the cameras were there. Every other person, um, has no problem with. I'm just confused, and sometimes you just look at shit and it just makes your brain go, "What the fuck?" Like I just can't. No, he's healthy. Everybody's yeah, everybody's as good as they can be. As required by the 4th, 6th, 8th, and 14th Amendments to the Constitution and Article 1, Sections 7, 9, 10, 12, and 14 of the Utah Constitution. Requiring Mr. Robbins to essentially republish through public filings the litany of unfair, prejudicial, and oftentimes inaccurate electronic media interviews, comments, and photographs, along with the necessary link citations, compounds the very issue Mr. Robinson seeks to address by the motion. Here's the problem, bro. Here's the problem. Your client is a defendant in a high-profile unaliving case. Guess what? He is not the first person to be a defendant in a high-profile unaliving case. See Karen Reed. See Kyle Rittenhouse. See Sarah Boone. Your client is not special. Stop acting like your client is the most fucking important person in the room. Like, the rights of your client are important. However, your client is not the first person to ever be in a high-profile unaliving case. O.J. Simpson, high-profile unaliving case, cameras in the courtroom. Kyle Rittenhouse. Karen Reed recently. Like, need we go on and on? All the trials that are streamed on every channel. I could name you 3 or 4 channels that have streamed a trial today. The Uvalde case. Like, it's just one of those, like, your client is not the only person who's ever been through this, so there is a shit ton of case law that is not on your side. Sorry, bro. Sorry about your luck. Because guess what? When you are accused of a crime, this is why, like I told freaking Lips, PSA, if she ever sees this, don't trauma dump in legal filings because legal filings are public information. Sorry. That's why public information and legal filings need to be specified to legal issues. Like, limiting the overwhelming electronic media exposure, in this case, that fixates on every sound, image produced from the courtroom. To be sure, the inclusion of the publications, which are by no means exhaustive, in the motion is necessary to fully present all aspects of the constitutional problems presented and to create an adequate record. Mr. Robinson should not be forced to sacrifice his right to a fair trial in republishing prejudicial materials necessary to adequately raise the issue before the court. Should I buy a set of cheap, like, fake pearls to, like, clutch when I read these motions? Like, I used to be on the side of most defense attorneys because I understand you would have a job to do, but now every defense attorney I see, I'm like, you're wanting your client to be special. And it's like your client is not any more special than any other defendant in this country. Sorry about your luck. And there's years of case law. Years of case law. They were bringing stuff back from 1982. There's years of case law. And I'm sure all the case law that the news media mentioned is only scratching the surface. Like, and I'm sorry that your client is talked about negatively on the internet. Welcome to fucking 2026. Is this your first day in the 21st century? Did you just time travel here from the 80s? Because welcome to being talked about on the internet. Grow a thicker skin. And if your client can't handle being talked about on the internet when he's a defendant in a high-profile unaliving trial, that sounds like a you problem that you might want to discuss with your client. They are just throwing things against the wall, hoping one sticks. I don't know. I can see not liking certain things. I totally understand that. But remember, there's always a difference between what we want to happen and what we think should happen and what is actually plausible and constitutional. And your rights don't trump somebody else's. That's the thing. I think that's the thing that a lot of people get wrong these days is your rights are not any more important than anybody else's rights. And your rights end where another person's start. I'm like, Your Honor, my client is not special. He's special. Stop. Ugh. All right. Next, Mr. Robinson is concerned that republication of the harmful materials will materially impact the case. In the past, electronic media have utilized public case filings to make inquiries of local officials about whether their commentary about Mr. Robinson and the case have negatively impacted his ability to obtain a fair trial. See Wendy Holleran, Governor Cox question on accusations of prejudicing accused assassin Tyler Robinson's case. The cited electronic media article is demonstrative of how public filings raising important concerns can develop into media coverage that impacts the proceedings as noted in the motion to exclude. Shut the fuck up. Hey, Lexi, how are you? It's so good to see you. It's been a little bit. I hope you are doing well and Happy New Year. Honestly, bro, this had to be Father Time that wrote this, the lawyer with the liver spots. Hey, Mouse, how are you? Everybody's just hanging out today. I love you guys. For those of you who are just joining us, this is the motion from Tyler Robinson's lawyers to seal or to make private the motion to exclude the cameras from the courtroom. If it sounds confusing, the way they worded it was just weird. But they are arguing that their client, TLDR, is way more important than everybody else and that cameras shouldn't be there and that we should seal all his shit because he will not get a fair trial if people have access to documents. I just can't. The cited electronic media article is demonstrative of how public filings raising important concerns can develop into media coverage that impacts the proceedings, as noted in the motion to exclude. In addition to the republication issue, Mr. Robinson makes reference in the motion to existing filings in the court record that are currently classified as private. Guess what? That sounds like a you problem. This is what sounds like a you problem. That doesn't sound like a me problem. Or a media problem. That sounds like a you problem. It's real simple. If you don't want media scrutiny, don't do anything the media thinks is worth checking out, i.e. unaliving folks. Yes, and he is innocent until proven guilty. Remember that. And there are plenty of innocent people who have been accused of unaliving people, i.e. Karen Reed. However, I also don't think it's just the victim in this case that's garnering public. There's been so many people in this that have come up with so many conspiracy theories, like Israel did it. Even people saying that Erica Kirk had something to do with it. Like, yes, I just wanted to be a single mom to be a single mom. That just sounds like such a fun time to be a single mom with a 2-year-old and a 1-year-old. Just sounds like an amazing time, doesn't it? Like, I don't know. But filings in the court record that are currently classified as private, namely the private portion of the December 11th, 2025 hearing transcript from the closure hearing and the state's response to the defendant's motion to appear in all person proceedings in civilian clothes without restraints. Given the classifications, and this one I didn't understand either. No other defendant that I've seen ever is awarded without restraints. Freaking Sarah Boone was on camera all of her pretrial hearings in her prison or her jail jumpsuit with her pink handcuffs. Like they act like Tyler Robinson is the first person to ever go on trial and he's special. You're at the end of the day, Charlie Kirk, although people knew who he was, just a civilian. State case, just a civilian. No different than any other victim in this country at the end of the day. Which means Tyler Robinson, at the end of the day, is no different than any other defendant in this country and should not receive special treatment just because his supposed victim was well known. I'm so sick of my client is special and deserves this. No, your client doesn't deserve anything else than anybody else in that Utah County jail gets. Sorry, just because people know who your client is versus knowing who Joe Schmo ABCD in, the jail currently is, it doesn't matter. Your client is no more important than anybody else. And I understand they have to fight for him, but at the same time, it's like what they're fighting for is stupid hills to die on. Given all the classifications of these records, it would violate the Utah Rules of Judicial Admin for Mr. Robinson to publicly file the motion with these references. Sounds like a you problem. Finally, Mr. Robinson raises several points in the motion concerning the publication of the private information of individuals involved in this case by state and federal government officials in violation of the GRAMA and federal rules. These arguments necessarily require descriptions of the private information that should not have been disclosed. Requiring Mr. Robinson to republish private information that should not have been public in the first instance, again, compounds the problem and perpetuates the harm to Mr. Robinson and other individuals whose private information was made public. Mr. Robinson should not be put in the position of choosing between fully erasing the privacy violation issues or foregoing these important arguments out of concern that further privacy violations will occur through public filings. Well, guess what? Your client is a defendant. Anything you put in there is by the Constitution of the U.S., First Amendment, public information. So guess what? If there's private info in there, do you know how many other defendants have had their public information or their private information shared in public documents? Guess what? It's called redaction if you're going to share them on the internet. But they act like they're the only freaking people who have ever been. Dude, is this your first day on the internet? Is this your first day filing public motions? Oh, wait, no, his lawyers are from California where it's very hard to get any documents. Utah, you can get documents. That's why they're pissed. Utah, you have to pay for documents, but you can get them. Could you imagine if these lawyers were trying a case in Florida? Oh my freaking God, their heads would explode. I'm just saying. Because could you imagine these lawyers going to Orlando and trying a case with Judge Cranick, the Sarah Boone judge? Oh my God. I could not imagine. I would pay to see that. I would pay to see them be pro hoc vice in Florida. Just to see. Sorry, that one made me smile. Because their heads would explode. If they think they have privacy issues in Utah, good luck in Florida. Like, oh my goodness. Oh. All right, these footnotes. Mr. Robinson even hesitates to include this reference here for the same reasons. However, the court should be aware that negative impact of republication through public filing is very real. Suck it up, Buttercup. Suck it up. Defense counsel is working with the state and media council to agree upon redactions to this transcript and acknowledges that portions of the referenced in the motion are likely to become public. However, at present, the transcript is currently private unless defense counsel notes this in abundance of caution. Insert eye roll. Pursuant to Rule 4-202.043a, upon the filing of a motion, the court must deny access to the record until the court enters an order. Accordingly, Mr. Robinson requests that this court classify the motion and exhibits as private, pending any further order of the court. This order reminds me of Lips trying to get Jeremy's lawsuit, or her lawsuit against Jeremy, classified as private. That's what this reminds me of right now. They wouldn't. Well, in their defense, I don't think anybody does well with Judge Grudge. However, you know. Oh, and I forgot to mention something I was told. Apparently, me and some others here are criminals because of stolen valor. Me because the Pentagon would not send them anything, citing no security clearance. Huh? You're gonna have to DM me that, because that's hilarious. Like, that's hilarious. There's only one idiot that I've ever seen accuse anybody else on the internet of stolen valor, and it didn't go well. All right. So these are his lawyers. I just don't care. All right. So we have one more. This is from Erica Kirk. So this is the one that people on the internet, especially those conspiracy theorists that think Erica Kirk had something to do with this, and we don't entertain conspiracy theories here. We go off what the court says, because I don't do conspiracy theories unless they're based in fact. And all I've seen is some crazy shit with some people that I think need some padded walls. Specifically, someone who I used to follow and admire, who's being sued by the First Lady of France's by the First Lady of France for defamation. So, like, I have a question for you. Gonna DM you in Discord? Okay. Hope I can answer it. I don't have my phone right now, so All right. Let me just close this real quick. Let's see. And thank you to the 34 people who have hit the like button on this stream. I appreciate you. 36. But thank you to the one person who hit the down button. Y'all crack me up. Oh my goodness. You hit the down button for this, but not for the What the Hails. The What the Hails stream doesn't have any dislikes on it. 191 likes to 0 dislikes. Like, be it there was like 270 something people in there at one time, so 100 people didn't really do their job, but just saying. we're just gonna leave that one out. But all right. Let's see. Let's go back to this one. Oh, I only have 4 windows up. I'm like, all right. Invocation of speedy trial rights. Comes now Erica Kirk by and through undersigned counsel and hereby asserts her right under Utah Code 773872 as the victim representative to a speedy trial. Hey, Jeff, if we would have actually read the first paragraph of this motion, we would have not had to resort to questioning what the statute was. And I do have the statute up, thanks to ChatGPT going, hey, what's the ChatGPT really good? Hey, what is the so-and-so state statute for this particular law? ChatGPT is really good at providing that because it will give you links. Yes, granted the Sixth Amendment right to a speedy trial. However, that right has been affirmed as a right of a victim as well, specifically in Utah Supreme Court, Utah v. Renzo. Well, so I'm assuming how this is a sentence that's going to become like how this is controversial. We don't know. It's because you have people on the internet who think they are smart and are not smart. For example, story time with Squid. For example, totally off topic, but Indiana's quarterback, Fernando Mendoza, won the Heisman Trophy, won the national championship. You had people commenting on various Facebook like pundit posts or YouTube channels like On3 or other sports channels, and he entered the transfer portal the next day. Just so we're aware and we're on the same page, this is my problem with America. Thinking you're smart and not being smart. For those of you who didn't know, Indiana's quarterback this season was Fernando Mendoza. Their backup quarterback was Alberto Mendoza, his little brother. His little brother entered the transfer portal the day after they won the championship. So you have people on the internet making comments on Facebook or YouTube about, oh, and Indiana's quarterback Mendoza entered the transfer portal. It's like, you stupid. Are you always this stupid or are you playing for the internet? Like, educated beyond their intelligence. So getting this back to the law side of things, we have shown how many people, and I'm not a lawyer, so I don't completely understand the system, but that's one of the reasons that we read documents is so that we learn how the system works. But there are so many people who think that the FBI is in charge of this case. It's like, no, the FBI is assisting because they knew Charlie, and Charlie knew high-profile people. This is a state case. Like, well, why hasn't this been released? Because if you've ever watched a murder trial before, like the autopsy generally doesn't get released until the trial because it's evidence. The only people that the state has to release any of that shit to is the defense. Not Joe Schmo on Twitter who's pissed and has made up in their own mind that they know what the fuck is going on and they don't. Like, and hey, Squaw Bob, how are you? Like, so you have a bunch of people that have no idea about Utah law, have no idea about victims' rights in Utah. They're like, well, she's not the victim. She's the victim's representative because the victim is dead. I mean, it seems like common sense to me, but apparently this is like rocket science for some people. I don't know. This is aeronautical engineering 101 for, Sadly, Fernando's reward for winning the championship in Heisman is going to be drafted by the worst team in the NFL. I don't think he's a junior. So for some reason, I think he's going back. I just think he's going back. I think he's going back. I don't know if he's going to declare. Did he declare for the draft yet? I don't know, but that's another time for another place. All right, Utah Code 773872 as the victim representative to a speedy trial. No one believed in the importance of the U.S. Constitution more than Charlie. And although the U.S. Constitution guarantees criminal defendants many rights, it does not guarantee them the right to cause undue delay in the criminal justice system process. Oh, that's your map? Are we searching for treasure?
Yeah.
The defendant in this case is entitled to a fair trial, and he must be given one. Right here. But he is not entitled to cause undue delay in the criminal justice process. The Utah Code affords victims of a crime the right to speedy disposition of the charges, free from unwarranted delay caused by or at the behest of the defendant, and to prompt and final conclusion of the case after the disposition or conviction and sentence, including prompt and final conclusion of all collateral attacks on dispositions or criminal judgments. You're dropping all mommy stuff. He's predicted to go to he's predicted to go, but just because he's predicted to go doesn't mean he will, because he still has to declare. Everybody can predict that he's going to go anywhere, but if he's not going to declare for the draft, then he's not going anywhere. Just saying. If you have your spouse unalived, you're the perpetrator, not the victim. Have your spouse unalived and tell me you're not a victim. But there's no proof. There's no evidence. If you got evidence that she had anything to do with it, I'm all ears. But show me the evidence, because, Stop. Stop touching my monitors. Stop touching my monitors. This court is tasked with the critically important function of ensuring the defendant has a fair trial, but this court must also do so while balancing Mrs. Kirk's right to a speedy trial, and therefore this notice invokes Mrs. Kirk's rights under applicable Utah Code. So that's the whole page just for the date. This was filed January 16th. With that being said, stop messing with my Stream Deck. Here is stop messing with my Stream Deck. Stop touching my Stream Deck. Stop it. Angel Bug, we have to go. Go get mommy's phone. Can you go get mommy's phone? You paid? No, I didn't pay for. Those were state documents. Those were paid for, not by me. Those were paid for by Andrea Burkhart. She puts them on her Substack. I did pay for her Substack, but I paid for her Substack for the entire year because I would rather support her work than pay the state of Utah anything. So I did not pay for that. I'm saying that if someone's saying she's not a victim, they should have it happen to them and see, yeah, I said it poorly. Okay, I don't think she had anything to do with it. Okay, thanks for clarifying. That makes so much more sense. And that makes so much more sense knowing what I know about you and you as a person. Yeah, okay. Angel. There. So, so here is one of my favorite websites for law stuff outside of Cornell's Legal Institute is, I don't know where it is, Angel. You got to go find it. Is Justia. Section 9, representative of victim court designation, because people are saying, well, she's not a representative for a victim and stuff like that. These are just some of the things I've read on social media since she filed this paper. Representative of a victim court designation and representation in cases involving minors, photographs, and unaliving cases. So we're going to skip down to a victim of a crime may designate with the approval of the court a representative who may exercise the same rights as the victim who is entitled to exercise under this chapter, including pursuing restitution. Except otherwise provided in the section, the victim may revoke the designation. So number 2 is what applies here. In cases in which the victim is deceased or incapacitated upon request from the victim's spouse or parent, child, or close friend, the court shall designate. Can you go get the other one? Can you go get the other one? There's a half-eaten one.
No. Banana.
Can you go ask Grandpa for the other one? The court shall designate a representative or representatives of the victim to exercise the rights of a victim under this chapter on behalf of the victim. The responsible prosecuting agency may request designation to the court. All right. So, in any homicide prosecution, the prosecution may introduce a photograph of the victim taken before the unaliving to establish the victim was a human being. Sad that we have to do that. Identify the victim for other relevant purposes. I mean, yeah, and she was designated by the court as the victim representative. So in what she cited, let's see, 3872. Let's see, talk code. Let's see. 38. Let's see. Victim's right to a speedy trial. 7.2 is what she stated. What that reads is the victim of a crime has the right to a speedy disposition of the charges free from unwarranted delay caused at the behest of the defendant or a minor and prompt and final conclusion of the case after the disposition or conviction and sentence, including prompt and final conclusion of all collateral attacks on dispositions or criminal judgments. Here's the thing. There's another thing. Why is she trying to get this over with and I've heard things, and this is me paraphrasing what I've heard. I've heard things such as she's trying to get, this over with so quick. She's trying to get this over with so quick. She's trying to get him put behind bars and not a fair trial. No, she is trying to move the hell on with her life. And being a single parent and now the CEO of a company, which might have always been the plan if he were to be unalived, but just because something is the plan doesn't mean that you want it to happen. It's one more thing that is going to help her heal. And she's not my favorite person in the world. Like, I'm sure we disagree on a lot of shit. However, her husband was unalived in front of her, and now she's the single mom to 2 children under 3. Like, and I've learned in covering enough of this shit is you're always going to see someone on the internet who has an opinion about something. 9 times out of 10, they're wrong because they don't know what the hell they're talking about. However, even if I didn't like her at all and I thought she was an awful person, like, what victim of any crime wants shit dragged out for years? See Jeremy Hales. Who wants this shit dragged out for years? Absolutely no one. You want it over as fast as possible. And guess what? In Utah, she has the right to petition for a speedy trial despite the defendant waiving it, because the Utah Constitution and Utah law says she can. Just because someone on the internet doesn't fucking like it doesn't mean that she's not entitled to do it according to the law. And that is where I have a problem with people. Because people start talking before they know what the fuck they're talking about. It's always that open mouth and start talking before you engage the brain and common sense and the fact that, I have absolutely no idea what Utah law says. I have absolutely no idea what the hell I'm talking about. But I don't like her, so I'm going to open my mouth and make myself look like an idiot anyway. These people are dumb. This is why I don't do the conspiracy theories here, except to dispel them. Because of the fact that it's just stupid.
She's eating a banana.
Thanks. And I know Jeremy and Jacob's not here. Jay's never here. Jay's probably sleeping. I did talk to him this morning, though. Well, I didn't talk to him. I commented at him on Rosalind's stream this morning. But because they were giving a Laura Owens update. Trust Spawn's opinion on cheating. He's not here to defend himself. All right. On that note, though, I have to get going. It's time for family time. But thanks for hanging out with me on not one but two streams. And thanks to the 30-some people that came over here from the other stream. Eventually, I would like that number to be 50, 60, 70, 100. But, I appreciate everybody who's here. Oh, backhoe. Yes. Oh, no, it's not that. So we have a very small backyard because half of our backyard is like trees. You can kind of see the neighbor's yard behind us, but we have a row of like maybe 10 to 15 feet of trees. Some of them are living, a lot of them are not. It's just really bad. It's just really bad. I would like to rip out my entire backyard and plant better grass, redo everything. However, with that being said, yesterday, Mr. Squid comes to me. He's like, what would you say if I ripped out all the trees in our backyard? Okay, fine. 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 He wants to get a he shed. He's going to put a 12 by some odd foot shed in our backyard and make a home theater. On that happy note, he's home. So I got to get going. Plant things. So, we're going to have a construction project. And we're going to have a big ass shed. He's going to have a he shed. Since I have a quarter of the garage with a home gym, he's going to have a he shed. Go, sure, good. We're going to have feeder seating. Maybe we'll have a section for the lawnmower and stuff so we can get that out of our garage and maybe put one of our vehicles in the garage. Maybe, because half of our garage is lawn stuff and then half of our garage is home gym and golf cart. He shed. Yeah. Not a she shed. A he shed. So, yeah. I think Squid should confiscate the shed and make it a stream room. Well, on that note, I am going to get a room divider. Maybe he'll put his computer out there too. Just saying. Just a thought. So I can have this whole room to myself. And but the thing is here's the thing though, if he takes his computer and puts it out in the he shed, half of this room is going to become a guest room. But with that being said, I'm going to get a room divider because the warehouse, not the warehouse, it's a freaking manufacturing plant that I am helping with on Monday nights. It has a little kitchenette area with a nice room divider. And I was like, you know what? If I put felt backing on one side of that, and I put this foam stuff that I have here on the other side, that would be a nice room divider. And then maybe I wouldn't be so damn loud or I wouldn't annoy people all the time. Everything him goes in the he shed. So on that note, I have most of this room. I have this entire closet. I have a quarter of the garage with my home gym. I tend to have most of this stuff. With all of the, but taking this into account, I got a genius idea. So, be it that was Christmas, and Walmart had these nice. They were supposed to be ornament holders. Well, they end up being very nice for cords and extra SD cards and nice stuff. I have 2 of them, and they fit very nicely on this shelf right here. They don't really go. They don't really go with my aesthetic because they're red, and everything here is like dark black. Like the desk is black and all of that, but they make keeping everything in one area and easily accessible very nice. Happy wife, happy life. You want to know 90 people didn't own a garage, don't use it to park cars in. I wish we technically do have a vehicle in there. We have a golf cart. So our golf cart is in there. And his truck will not fit in there. So, red good, you can't lose them. Yeah, it's Christmas, but they were like less than $10 at Walmart. And it was like, they're supposed to be for ornaments. And here's the thing. If I ever want to change this, now I can use those for ornaments. All right. But on that note, guys, I will keep you on updates on the Squid Family construction project. Because now I know why Mr. Squid's been working so much damn overtime. 12 by 20 shit, it's not cheap. But we will I need to go have an MRI done on my neck, arthritis and degenerative disc. They want to see how bad it is. Good luck, almost Boomercraft. Good luck. It's so good to see you, and I hope everything works out. Those would work for my computer stuff too. Got them at Christmas time, so they might still have them online and they might not, but Walmart is great for stuff like that. Let me know when he wants the network run to the shed. You'll do it. Do you know how to DM me with ideas on how to run electrical out there? If you got ideas on how to run electrical out there, let me know. All right. Y'all have a great day. Timothy will be in touch. Have a good one, guys. Bye.